Good afternoon. Good morning to some. I'm Jayne Dixon Weber, the Director of Education and Support Services at the National Fragile X Foundation. I would like to welcome you to today's webinar, Using the ABLE Act and Special Needs Fairness Act to Establish Financial Stability and Independence. Before we begin, I want you to know these webinars are made possible by your donations. Thank you for your ongoing support. We have, maybe a 30 to 40-minute presentation, and then we'll take questions for the remainder of the hour and use the question bar on the right side of your screen. You can type in questions at any time. Today, I would like to welcome Patricia E. Kefalas Dudek. She's the principal of Patricia E. Kefalas Dudek and Associates, and the past chair of the Elder Law and Disability Rights section of the State Bar of Michigan. Her practice concentrates in elder law, Medicaid, estate planning, estates, trust administration, probate, administrative law, and disability advocacy. Her practice includes advising and preparing estate planning documents, including special needs trust, representation in Medicaid hearings to secure appropriate services, administration of estates, trusts, guardianship, conservatorship, and other protective arrangements, and any contested litigation in these areas. Welcome, Patty. It's great to have you today.
Oh, thank you so much. Thank you all. So I wanted to start today's webinar with talking about what you need to know about ABLE Act accounts, and then to talk about how you can use them or in collaboration with special needs trusts to maintain independence and financial stability. So I'm going to be starting now at slide number 2, and that is when ABLE Act accounts started, we were a little concerned about how they were going to be used. When I say we, I mean a lot of attorneys and so forth. And so let me just start at the basics. So ABLE Act account is an account where a limited amount of money, and that amount of money is defined by the amount that you can make a gift without a gift tax consequence. So it'll change every year. And that can be contributed to an ABLE Act account without disqualifying the beneficiary from needs-based public assistance. You're going to hear me say those words, needs-based public assistance. Those are the programs that we love to hate. We love them because they make life easier for our loved ones with disabilities, but I love to hate them because sometimes they have really ridiculous rules. And the ABLE Act is not available as a resource when determining eligibility for needs-based public assistance programs, and that is a miraculous thing. So a person has to qualify to be able to use an ABLE Act account, so it can't just be anybody who's poor. It has to be within the requirements of the law. And there are some restrictions on how the money can be used without adverse consequences, and we'll talk about those. But really, quite honestly, if you guys have any experience with special needs trusts or even ticket to work programs or PASS programs, an ABLE Act account is significantly more flexible than those programs are. And I think you will see that because they're so much more flexible, you'll see what some of the creative options we can do with them are. So let's go to the next slide, please. So, you know, the more they look, the better they get. We didn't like them. Primarily, I did not like them because they do require a payback when the beneficiary passes away to the state that had provided Medicaid benefits to the person. Now, in particular, I didn't like this because I saw lots of advertising and hype for these accounts as being a way for parents to save money for their kids' education, similar to a 529 plan, which is a tax-free way to save for education past high school, Or even in the old days, a lot of people used what was called a Uniform Gift to Minors Act account. So if this account is funded with money that comes from third parties, the third party is subjecting the amount in this account to this payback. And that is a huge, significant risk that I think is not spoken about enough. That doesn't mean that these aren't still a great tool, but in the beginning, that kind of really put me off the use of these for my clients. And when I say my clients, I mean often I'm talking about doing estate planning for mom and dad who may have a loved one with a disability, or even the grandparents. Now, if the ABLE Act account is funded with funds that are not third-party funds, but are first-party funds, which means the beneficiaries own money, then the payback is not as big of a deal, because if they were to do a first-party special needs trust, which we'll talk about more, the same type of payback is required. So I always thought, okay, I'm going to like these ABLE Act accounts, but I'm probably only going to use them when the person with a disability needs to put aside money to qualify for needs-based assistance programs. I probably won't encourage my clients to do this because I don't want to subject the money to a payback upon death. Now, let me just say, this is a philosophical issue I have with the states, that if the payback that my clients had to pay on any first-party trust or an ABLE Act went to be used for match dollars for additional Medicaid long-term support services to people with disabilities, I probably would not feel so bad about it. But we have some history here in Michigan where when they collect this money, they usually use it to pay for more attorneys in the Attorney General's office to fight with us about appropriate services for people with disabilities. So I really saw that as helping them pay to fight my clients in the future. So I feel pretty strongly about it. I'm not sure all advocates or attorneys feel nearly as strongly about it. Excuse me. The other reason why I thought that an ABLE Act might not work as well as we had hoped is because it is limited to the amount of money that can be deposited each year. Excuse me. So if my client received, for example, a retroactive back benefit from Social Security disability income, which used to happen frequently because they may not have stayed in touch with their loved ones. Sometimes people were placed in an institution and they didn't stay in contact with their parents, and then their parent dies, and it takes Social Security a bit to figure out that person's entitled to back SSDI benefits, and then all of a sudden they get this big lump sum payment. Well, frequently those big lump sum payments are going to be for more money than you could deposit in the ABLE Act account. So my feeling was, well, it's going to have some limited uses. It's also limited to only a person who became disabled under the age of 26. Now, that is not a huge limitation, but it is a rather arbitrary limitation. So if I'm working with a person who is 50 years old and they want to put aside some money because they're working a part-time job and they're having a hard time staying under the $2,000 asset limit for SSI or Medicaid, as long as they became disabled prior to the age of 26, they can still use these. But we're starting to see now that the legislation has been around for a bit and the accounts are actually being funded, and this mechanism might be a really good thing for people who were disabled later in life, in particular people who might have had a closed injury or something like that and had been working. And so I think that you're going to see some growth in this area about the types of accounts. So anyway, as more is learned about the ABLE Act accounts and the rules, and I mean some of these rules are really new. Like I believe the POMs, which are the Program Operational Manuals for SSI, only came out with their instructions about a year ago. on these. So the more we learn about the rules, we're learning that there are lots of possibilities, creative possibilities, and they are a great tool to use. Okay, next slide, please. Okay, so the ABLE Act account is named after Stephen Beck Jr., and ABLE stands for Achieving a Better Life Experience. Now, could you think of a better objective for having one of these? I just think it's fabulous. So the states were allowed to establish and maintain a tax-advantaged savings program called the ABLE program that benefits certain individuals who have a disability. Qualified individuals can open an ABLE Act account. So that means the person with a disability can open their own account, which is really flexible and nice. Proper contributions to and distributions from ABLE accounts are not, and as you can see in this slide, I capitalized not, income or gifts for tax or needs-based public assistance programs, including but not limited to SSI and Medicaid. But that also includes food stamps, it includes waiver programs, and we're still trying to figure out exactly what HUD's going to do, but there's a catch-all provision that HUD uses that I think is going to make us be okay with those too. Earnings and gain in an ABLE Act account are not taxable income, so it grows tax-free, sort of like a 529 plan does, if you're familiar with those. And the interesting thing is this statute that I put up there, the 26 U.S.C. 529A, this is a revision to the IRS code, which is something that most special needs advocates and planners aren't quite as familiar with as they are other things. And so it's interesting to see the way they came about with the rules for these. It was really more about how to handle similar types of tax-free accounts rather than special needs trusts. So next slide, please. So here is the law that you need to know about. And we have provided hyperlinks. If they don't work, feel free to email me and we will send you these with the hyperlinks working. We were setting them up as we were getting ready for this call because some of them were so new, in particular the last one, which is the state Medicaid director letter. So what happened was CMS, which is the Center for Medicare and Medicaid Services, is sort of the federal administrative arm related to Medicaid programs. And they frequently will send out letters to the Medicaid directors giving guidance about how they think something should be handled or administered. If you are an advocate working with folks who need Medicaid frequently, it might be a good idea to go to that website. There's a state Medicaid director website. They have an organization and they put out a newsletter and they will share whenever these state Medicaid letters come up. So this was a rather recent thing, so I tried to provide you where to go when you needed these details. Next slide. So what does it mean when the government says you must be sufficiently disabled prior to the age of 26? That's a really good question because it is not limited only to receiving SSI, SSDI, childhood disability benefits, or disabled widowers benefits. So often we are so used to getting that determination through the Social Security Administration, but to be sufficiently disabled for ABLE, it could be considerably more flexible. So for example, if you're getting one of those, you're golden. But if you're not, there are other ways that you can figure it out. So one of the other ways to do that would be to have a satisfactory disability certification. And that certification can be prepared by the individual parent or guardian or conservator if there is one, must be accompanied by a copy of the diagnosis, and must be signed by a licensed physician. So this certification sounds to me a lot like it might be from a 504 plan that somebody's getting services in the school district, or an IEP that they might be getting services in the school district. Or if they're not connected to any program, it might be the doctor saying that they're disabled. In particular, you might see that when someone has a legal blindness. They may not be getting a whole lot of services, but they would still qualify as a person with a satisfactory disability criteria. So this is all you have to do to become eligible for the individual. I would suggest, if you're working with folks who do not already have one of those federal qualifications, that you make sure that the letter cites the satisfactory disability certification and eligible individual, that the doctor believes that they are sufficiently disabled. Doctors don't like to sign things, especially now when they can do so much electronically. So what I suggest to some of my clients is to draft a letter and send it to them. So all the doctor has to do is sign it, like a blank prescription form. All they got to do is sign it if they agree, and give you the records. So let's go back there. So next slide. So I am now on slide 7. So there are some rules. So you can only have one ABLE account per person. So you can't game the system by having one in each state. It must be established by the eligible individual or a parent, guardian, or power of attorney agent. Now, the interesting thing about this is, keep in mind that the money can come from any of those sources or even third-party sources. So this is just who establishes the account. It is not whose money goes into the account. Only cash can go into an ABLE Act account. So a lot of folks I work with have savings bonds, and they may be getting close to the time where they may need to apply for SSI or Medicaid for long-term care support services. And then the parents are asking, well, what do I do with all these savings bonds Grandma and Grandpa have? Well, there is a way to put savings bonds into a special needs trust and not have to cash them in, right away. You could still just hold them in the form of the bond. However, that is not something you can do with an ABLE Act account. So you can't put a car in there and then sell it, or put a CD in there. It has to be cash. And that also happens, it's kind of interesting, that sometimes families buy stock. Oftentimes it's the stock of the company the family member's parent or grandparent might work for. When I was little, I had stock in the company my dad worked for. I thought that was really cool because it made me his boss. And sometimes people get stock, like if you get a Disney stock certificate, sometimes they're printed with the Disney characters on it. So I know that's a very common gift from grandparents as well. So those stocks would have to be cashed in. So this is, again, not a perfect answer for everybody. So then we talked about what the maximum contribution is, and that uses the IRS present interest gift tax exclusion, which for 2017 was $14,000 a year. So that is the maximum amount. So that's what I meant. You couldn't game it by having a $14,000 ABLE Act account in each state and have more growing there. You can't do it that way. It's $14,000 max, which means the beneficiary could be saving, and they could save, $2,000 to $3,000 that year, but their parents could contribute the rest if they wanted, or their grandparents or whoever. So there are some rules. So while you have this ABLE Act account, as long as it does not go over $100,000, you will continue to get SSI. If you reach over $100,000, your SSI will be suspended. Now, if you have $100,000 in an account where it's pretty flexible how you use it, you're the beneficiary who's the person with a disability, you have a lot more control over this money than you could ever have over a special needs trust. You may not care about the cash benefit, and you just are worried about keeping Medicaid, because right now, assuming all things stay the same in the area of long-term support services for people with disabilities, Medicaid is what is the payer for those services, usually under a waiver, but not always. So Medicaid can never be affected. Contributions may be prohibited if the account is too large. So again, if you get up to that $100,000 amount, you may have the ABLE Act folks pushing back or the government agencies pushing back saying you can't continue to make contributions. But we haven't seen that. This law hasn't been around enough yet for us to really know how that's going to play out. So stay tuned. Okay, slide 8. So an ABLE Act account cannot be pledged for security for a loan. And I think that's a good thing. I think that we've got folks with disabilities who are going to be primarily able to manage their own money. And so we don't want to make it too easy for other third parties to access that money. We want to make sure it's being used for the person who the ABLE Act account was set up for. An ABLE Act account can be rolled over into another one once every 12 months. So if something happens and we find out that grandma or grandpa opened one by mistake or whatever, you can roll them into one so that you only have the one account, because that's all you're supposed to have. So you can fix problems if you need to do that, but it is limited to only once every 12 months. So if there was a second account that was created by mistake, you may need to cash it in or spend out. Okay, now the beneficiary on these, what happens when the person who is the named beneficiary can't use the money anymore or passes away? Remember, there is that payback we talked about earlier, but the designated beneficiary can change to a brother or a sister, and the brother and sister could be a stepbrother or sister or adopted. They do not have to be only purely biological, which is rather flexible, I must say, in this day and age, given the IRS is the one who's interpreting this. Or if there's another family member with a disability who meets the criteria, you can roll the ABLE Act into that person's own ABLE Act, sort of like an IRA rollover, I guess I would say. If the person already has guardianship, then a protective proceeding may be required. Some states are requiring conservatorships and annual court accountings. I think, this is really going to depend on the judge. We have judges here in my state, some that are really, really hands-on related to special needs trust, and others who take a rather hands-off approach. Of course, this is going to play out over time, and stay tuned. Maybe in the next year or so we'll have an ABLE Act, Special Needs Fairness Act updating, and we'll see that the judges are not doing it. So keep your fingers crossed. Slide 9. So what do you use all this money for? So you've saved up now, and what can you use it for? So the IRS provisions say it can be used to pay for qualified disability expenses. We will use the term QDE for that. And those expenses have to be of the designated beneficiary or the eligible individual who established and is the owner of the ABLE Act account. So again, remember, it's for that person's use, but it may not be funded with money that came from them. It may have come from their parents or grandparents. So next slide, 10. So how do you define qualified disability expenses? And this is a rather broad definition. Any expenses related to the eligible individual's blindness or disability, which are made for the benefit of an eligible individual who is the designated beneficiary of the ABLE Act account, including the following expenses. Now, the important thing about this is if that designated beneficiary has a significant other who may also be disabled, you cannot use these qualified disability expenses for that significant other. It can only be for the person who the account is for. But then look how broad some of these are. Education, which, supplemental educational services, especially tutoring, may be appropriate. assistive technology, and personal support services. We really have problems sometimes accessing those services. In particular, a lot of times Medicaid may pay for the technology, but they don't want to pay for the assessment to determine what the appropriate technology is. So the ABLE Act account could do that. Also, sometimes assistive technology is pretty generic stuff, so Medicaid won't pay for it. So, for example, I have this wonderful iPad that has all kinds of assistive technology, things on there and applications that I can use. And the beneficiary may want something like that, but that's not something Medicaid's going to pay for. So, of course, it would be very appropriate for the ABLE Act account to pay for that. Legal fees, what's not listed here is also accounting fees if needed. Housing, that's a big issue. Most Medicaid waivers have a limitation on how much can be used for housing, or if any Medicaid money can be used for housing in the community. That's a real problem when people are limited to only using SSI or SSDI to pay their housing expenses. So that housing one is a big deal, and we're going to talk about that some more. Expenses for expenses for oversight and monitoring. Sometimes Medicaid will only pay for direct care, not someone to supervise the direct care staff or monitoring them, or to be the on-call person. Given all the extreme weather we have witnessed in this country this year, this is a big one, especially from me coming from Michigan. We frequently have ice and snowstorms, and frequently the provider of the personal support services or long-term care services gets stuck because of the weather. And it's not the person who's been trained and gone through all the authorizations and all that to get paid for by Medicaid, but it's a sibling or a neighbor or someone who comes in those emergencies. How are you going to pay them for what they did for you? This allows for that to come right out of the ABLE Act. Health is a good one. It's very generic. It covers pretty much anything. What I like about this is also sometimes people want a supplemental medical because of their unique medical needs related to their disability. Oftentimes people are connected to specialists. I'm sure many of you may have specialists who are more familiar with Fragile X or other disability conditions, and you don't want to lose your access to that specialist, and your specialist may not accept Medicaid. So some people do use their ABLE Act account to pay for supplemental health care. Transportation is huge in Michigan, huge, huge, huge. We do not have a lot of accessible transportation for those folks who are disabled, and so ABLE Act could do that, and that can really make a big difference in people's lives. Prevention and wellness. I have a chronic health condition. I spend a lot of money on stuff my health care does not cover, like acupuncture, like massages, those kinds of things, vitamins, and so that's not something Medicaid's going to pay for, so the ABLE Act can count that. One of the things a lot of advocates were happy about is the funeral and burial expenses. And primarily, we felt very strongly about allowing for funeral and burial expenses is because we have struggled with this issue forever. So by way of background, Medicaid will pay for a very minimal amount of coverage for someone who is a beneficiary who dies. I think in Michigan it's like $700. It barely covers, anything. So a lot of people who had first-party special needs trusts, which would be a D4A or a D4C trust, and I'll talk about some more of those in the future. These are the first-party trusts, so they require a payback to the state when the person dies or to be retained in the trust to help other people with disabilities. Well, the Social Security regs in the states took ridiculous positions saying that no amount of money after the beneficiary died could be used for anything, including funeral and burial expenses. And there's been all kinds of additional stress and nonsense that should not have happened to these families about whether they pay for it in advance or not pay for it in advance and what happens when somebody dies. This allows the ABLE Act to do it, so we don't have to worry about it anymore. If it's not already done prepaid, we do not have to worry. It can come out of the ABLE Act. So employment, training and support, financial management and administrative services, and other approved expenses. What I don't see here that we think would be really appropriate also would be phones, internet service and technology that allows you to stay connected to your family members and your caregivers, because that's certainly not something Medicaid will pay for. Now there at the bottom you'll see basic living expenses added by the POMs. So if you were working with someone who received SSI and they received a basic living expense assistance from a third party that was not a charity or a government, they could have their SSI reduced significantly. The ABLE Act does not have that same requirement, and that is a huge, wonderful thing we did not know about when the law first passed. This has come out since the law was passed and the Social Security Administration released their POMs. So next slide. So housing expenses. So if the person was on SSI and they got in-kind support and maintenance, which was help for any of these things listed here, that was provided to them by a party that was not a charity or the government, then they would have their SSI reduced by 2/3, down to 1/3 or more. This does not have that same impact. So if I have a person on SSI who wants to rent an apartment and their apartment costs $500 a month or $600 a month for rent, okay? If they're getting the maximum SSI amount, it's only going to be like $771 or something like that. They're not going to have a whole lot of money to pay these utilities and have food and have personal spending. That's why these housing expenses could then come out of the ABLE Act account and not reduce the SSI, because if the SSI got reduced by 1/3, they're not going to be able to stay in the community safely and have enough money to make it work. So, which is really nice. So what I'm telling you is that the Social Security POMs are very flexible about this. Next slide. But even more surprising, the IRS is flexible about this. So this quote I think is really important. So when they're looking at the distributions, and remember, it will be the IRS looking at this, not SSI, Social Security workers, not Medicaid workers, not food stamps workers, not HUD workers, only IRS workers. And they're going to be looking at it with this quote in mind, that the qualified disability expenses should be broadly construed to permit basic living expenses and should not be limited to expenses for which there is a medical necessity or which provide no benefits to others. These rules are all rules that relate to Medicaid and the use of special needs trusts. It does not impact ABLE Act accounts at all, which is a wonderful improvement. Next slide, please. So what happens if you make a mistake? If you make a mistake from a special needs trust or a family member makes a mistake and the person is on needs-based government assistance, frequently it is a huge deal. So what happens if you make an incorrect distribution for what you think is a QED and it's not? The income will be included in the beneficiary's gross taxable income. So that means the IRS will find it from an audit and make you do an adjustment. It will be deemed a taxable gift, or not nor, sorry, that's a typo on B, deemed to be income for Medicaid or SSI. Instead, a resource converted from one form to another. So if you were taking cash that was available and put it in the ABLE Act, that's changing a resource from an available resource to an unavailable resource. This is going to say it was available the whole time, okay? That's not a huge issue because that may income disqualify you for, a short period of time, depending how much the distribution was. So to continue this discussion, the next slide. So if it's not spent on that, it will not be considered disqualifying income for SSI and presumably also Medicaid. The reason why we say presumably also Medicaid is because each state's going to come up with their own interpretation for Medicaid. The SSI provisions are right here. I gave you the site for the POMs. Now keep in mind that the states are not allowed by federal law to be more restrictive than the SSI rules. So you would assume they would try to follow this POMS, but you know, I've learned over the years not to expect rationality when it comes to government programs. So a distribution from an ABLE Act account is not income, but is a conversion of a resource from one form to another. So again, you're taking the cash you had available, it's available, you put it in the ABLE Act, it is now not available. Do not count distributions from an ABLE Act account as income of the designated beneficiary, regardless of whether the distributions are for non-housing qualified disability expenses, housing qualified disability expenses, or non-qualified expenses. So it's a pretty broad term. So what we think that means is your SSI won't even kick you off if you make a mistake. It's just going to be a tax problem. Which I don't know about you guys, but a lot of the folks I work with, the tax issues are the least of their concerns. The bigger issue is the loss of the beneficiary status for SSI or Medicaid and the services that pays for. So next slide, please. Okay, so again, the consequences are taxable income to the beneficiary, taxed under the code section 72, and there could be a 10% additional tax as a penalty. That will be dependent on the total financial circumstances given the unqualified distribution. Next slide. Okay, so Medicaid must be repaid. Remember, we talked about that in the beginning, but they have some limitations. So if a person creates a D4A trust or a D4C trust, again, these are first-party special needs trusts, so the person who's already on SSI or Medicaid creates these trusts. When that person dies, they have to either reimburse the state or any state that has provided Medicaid services, or in the case of a D4C trust, the charity retains the funds to use them for other people with disabilities. ABLE Act is very similar to that, okay? So if the beneficiary with a disability dies, you have to reimburse Medicaid. Qualified disability expenses may be paid first. So again, if they have not prepaid their funeral and burial, and I don't know about you guys, but you know, if you're working with young folks with disabilities, the last thing they want to do is spend their money on a funeral and burial. I don't want to spend my money on that. Nobody does in advance if they don't have to. So this is a nice way to have peace of mind that it's going to be taken care of. Many states allow for a Medicaid buy-in premium. Those can be deducted from the ABLE Act. So if they paid those, they're not going to make you pay that back. So you're not paying twice. Slide 17. So when do we use these? So if you have a designated beneficiary who has the capacity to manage their own money, even if they're using an agent under a power of attorney or a fiscal intermediary for assistance, doesn't really matter, and that allows an additional $14,000 a year to be accumulated in addition to the $2,000 you already get to keep as exempt assets. Plus, the beneficiary will continue to have their other benefits, and that includes income they might have from working, because a lot of people with disabilities may be working under SGA, which is substantial gainful activity for those disability benefits, and if they are, that's additional income. They could work part-time. It would be great. So when else will we want to use these? And this is where I think I'm going to use them the most. Slide 18. So if I have a designated beneficiary receiving SSI, and the payment of housing expenses from any source other than the SSI recipient is in-kind support and maintenance. And that's not quite true, because if the housing expenses come from your government, a Section 8 voucher, wherever, then it is not in-kind support and maintenance. But if it comes from a family member or something like that, it will reduce your SSI. Distributions from ABLE Act account for housing expenses are not in-kind support and maintenance and will not reduce the SSI amount at all or Medicaid. So I think this is going to be my primary use of ABLE Act account. Next slide, please. So I'm going to go through just a couple illustrations. There are more in the slides, but I see I'm running tight on time, and I do want to leave some time for questions and answers. So what if you have a special needs trust already created? And it could be a third-party special needs trust. You should put permissive language in the special needs trust that allows you know, the person to do that. If you already have a third-party special needs trust, don't amend it. It's not worth that. But just make sure maybe in the letter of intent or something like that that you want the use of ABLE Act accounts to be allowed or supported. If it's a self-settled S&T, there's no problem with doing that. Okay, next one. Let's go to the second slide. Here we go. Gifts from others to the ABLE Act account. So, you know, I have a client who did this for their loved one who was graduating from high school. Because they were concerned that the people were going to be writing checks to this person and they were going to put them over the $2,000 asset limit. So we created the ABLE Act account, and they were all able to pardon the pun, put that money towards the ABLE Act account. There was really no downside at all to doing this except the subject to the payback at death. Well, we're hoping this young person with a disability at 18 will still have plenty of time to spend that $14,000 a year. And if they do or don't, then we'll have to plan for it. But that's the only negative to doing this, which I think is great. So remember, the ABLE Act then will allow the beneficiary to have more spending money that they have direct access to. They do not have to call and ask permission from an agent under a power of attorney or a trustee. Pays for some qualified disability expenses, especially housing, which is nice because you could set it up for auto payment, auto debits. It would be really user-friendly. So the next two slides, which are 21 and 22, talk about how to use a structured settlement with ABLE Act accounts or small inheritance. I'm just going to leave those for you guys to look at so that I can touch base on just a couple other things here. Then slide 23 and 24 are illustrations about how to use it if there was a Uniform Gift to Minors Act account or if the person was having a hard time staying under $2,000. Those are the other two illustrations. So now, I am now on slide 25. This is the list of the programs that there are. There are several different programs. It's hard to choose. Now, what I have learned is similar to 529 plans, you do not have to use the ABLE Act or Stable Act or whatever they call it in your state program in your state. So you may want to use a different state's program if those rules or investment criteria seems more flexible to you. So if you go to the next slide, 26, not all of them take people who are non-residents. So you see Oregon has two, one for residents and one that are non-residents, which I thought was interesting. So then go to slide 27. So there are 5 programs that are calling their accounts stable accounts. The one I'm most familiar with in this group is the Ohio program because we are close to Ohio, not because we're Ohio State fans. That program has been up and running for a while, and it has been really interesting to watch. So you want to know about that. There are also then on slide 28, 11 programs that are part of a national ABLE Act alliance. And so those states are all working together and using one party. Is someone breaking in? Okay. Just start. So where do you find information on ABLE Act? So the next step, it would be slide 29. So slide 29 is where you would find out more about ABLE Act programs. They have a very nice interactive map on the Able National Resource Center website. So we need to go to the next slide, please. I don't know if I lost people or not, but slide 29 will have those as well. And then I have attached a comparison of ABLE Act programs as of August 6th of 2017. It's a chart. It's not easy to read in the form of this PowerPoint. So if you want me to actually send you that chart, I'd be happy to provide it to you. Other things you need to be aware of just real quickly here is that there are pending ABLE Act legislation changes coming. And that's to extend these. So if you look at the first one, it permits tax-free rollovers from 529 plans. That seems to make a lot of sense to me because a lot of people start saving for college and educational expenses for their loved ones before they know that they're having a disability issue that they have to contend with. So it would be a nice, easy, tax-free thing to roll it over. And so that's what those other changes are about. There's also one to change the age of eligibility to 46, so as long as the person became eligible for benefits prior to the age of 46, they could open one of these, which would be nice. 4 allows excess contributions from work to ABLE Act accounts. I'm not really sure why you even need that one, because once the money comes into the person's hands, they can do whatever they want with it. So now I just want to touch base. There is a new law called the Special Needs Fairness Act, and that law also allows people with disabilities to open their own first or third party special needs trust. Prior to this new law being changed, which we often refer to as the Special Needs Fairness Act, you had to go to court in some proceedings to be able to do it unless you did a D4C trust. So this now fixes that. So a person with a disability can open their own ABLE Act account without going to court. They can open their own special needs trust without going to court, and you may want both and you may not want both. It doesn't, you know, it just kind of depends, and they can do it with their own money, or third parties can do the same thing. Third parties could do an ABLE Act account for that person, or the third party special needs trust. So this has certainly really expanded the amount of flexibility people with disabilities will have and their families to be able to have some more financial security, so they're not only limited to that $2,000, you know, in savings for these needs-based assistance programs. And I hope that you will find the information that I just went through very quickly, I apologize, helpful to you in making those decisions when you're working with folks. So last slide is I'm encouraging you to stay in touch. If there were questions that we don't get to today, feel free to email me. We do send out a pretty regular monthly email newsletter with a typo in newsletter. I apologize. We were doing this very quickly at the last minute. And also, I'm very active on social media, as I encourage all of you to be during this tumultuous time with lots of changes that could be coming to health insurance and public benefits for people that we love and work with, and that there will be alerts on all of those. And I encourage you to seek me out and introduce yourself and follow up if you have questions that we don't get to today. So I'm going to turn it over to the moderators to see if we have any questions, because I don't see anybody. I don't know if that doesn't mean we didn't get them.
No, we do have some questions. So some of these you've already answered, but I'm going to go ahead. I mean, it says, are ABLE accounts available in Georgia? Now, I can't remember the list that quickly.
Well, one, they're available no matter where you are. You don't have to use your state's issue. So even if Georgia doesn't have one, you can certainly open one in Ohio or wherever that accepts the ones from not in their state. And I'm looking, yes, Georgia has a stable account program. So on slide 27, Georgia, Kentucky, Missouri, Ohio, and Vermont, those stable acts seem to be some of the best ones. So yes. And if you have a hard time finding it, go to that National Resource Center link I gave you. They have a map of the United States, and if you hit on your state, they'll tell you, you know, what your program is.
Okay. Let's see. Someone's asking about a certificate of attendance and if we'll get a hard copy of the webinar. There will be a link to it that will be sent
Yeah,
out to everyone who's registered.
and I believe you're going to post it on YouTube too after.
Right, but there will not be access to a hard copy, will there, David?
That depends on whether Patty is okay with it or not. I know that there's
I'm absolutely okay with it if you let me fix those 2 typos first.
Okay.
Sure, yeah.
That'd be fine. Okay, it said Medicaid can never be affected. What about if the individual's SSI is suspended due to the high account balance?
Nope, you keep your Medicaid. It's just like if you lose your SSI because your parent passes away or retires or becomes disabled and you switch to DAC benefits, you get to keep your Medicaid.
Regarding the Medicaid payback, is there accounting for how much Medicaid benefit has been used such that the amount taken from an ABLE is capped at that amount? Or is there a set amount, or does all of it go to the state?
So there is an accounting. So if you put, let's say you've been putting $14,000 in each year and it's been growing, and you only got Medicaid for a year of that time, okay, the state will have to provide you the information about how much they paid for in services, and I encourage everybody to look at those bills because I've never gotten one ever that was right the first time. And then you can negotiate with the state and say, well, I agree with, 75% or 80% of this, but I never got these services. And then they'll usually negotiate it with you. And it's usually the state's third-party reimbursement section of the state Medicaid office you're working with.
Well, so like if you, I mean, this is kind of exaggerated. So, but if you have $14,000 in your ABLE account, but you've only received $10,000 in benefits.
Right. Then the $4,000 goes to wherever you want.
Okay. So you could get that back. You could theoretically get that money back. Okay.
Yeah. Mm-hmm.
Okay. Do you have a list?
The sibling that was alive, the sibling can take the $14,000, and that sibling, it's unclear to me. They do not have to be disabled.
So wait, on the ABLE account, you can transfer it to a non-disabled sibling?
Yeah.
Oh, I thought you could transfer it to a sibling, but only if they were disabled or had some kind of disability.
I don't believe so. I mean, you can do that transfer from one ABLE account to another, but it also says it can go to a sibling, and it's a very broad definition of sibling. It says step person. They don't even have to really technically be a sibling.
Oh, I thought you said, though, that they had to have some kind of disability, though, to be qualified.
No, I don't believe so. I'll triple check that, but I don't think it has to go to a person with a disability. Any sibling can take. You can do a rollover to another ABLE Act for a person with a disability, okay? So if you have a sibling with a disability, that's easy. But you can take it right out of the ABLE Act and give it to a sibling. They're most likely going to put it in a 529 plan or something else, depending on the age. So if let's say there's twins, one's disabled and one's not, they're going to let you roll that over.
Really? But then
yeah, that's my understanding. Now, I could triple check it, but that's what I think.
Okay.
And I didn't believe it at first either, so.
Okay.
It's too good to be true, doesn't it?
Well, it does, because then you'll be giving a ABLE account to a non-disabled person.
But you're not going to give the account to them. They're just going to take the cash out. They can't continue to be a beneficiary of that account.
Okay. Okay. Yeah.
They'll have to put it in the UGMA account or a 529. That's why I think that rollover to the 529 has been so popular, because a lot of people want to do that.
Well, so I have an ABLE account for my son. He passes away, but so in order to avoid the Medicaid payback, I give it all to I have it roll over to my daughter?
Correct.
Really?
Yeah, I think that's what, yeah, I know. It's a big deal.
Well, then theoretically, I mean, if people caught that, then they wouldn't have to do the Medicaid payback. They would roll it over to a sibling.
Exactly. And that definition of sibling doesn't have an age on it either. I was like, well, what if they're adults? I think time will tell how they play out on that, but right now they've contemplated young kids using these.
Yeah.
So if you have siblings, you know, one became disabled and one didn't, or they'll just let you, I believe when that legislation passes, they're going to let you roll it from the ABLE Act account into a 529 plan. But even if they don't let that, what people will do is take that money and probably prepay one of those college assistance programs or something like that with it. I think it has to be used for educational expenses. It can't just be given to them, you know what I mean? But
right. Well,
this is one I will look up because I think it's going to be a frequently asked question.
I think it is too. Well, I think people are going to are going to want to know if they can avoid that Medicaid payback.
Amen. I agree.
Yeah, like what are my options? Okay. Will you be listing expenses that are not qualified?
No, because I don't know what they are yet. The definition of what is pretty broad. I would say, if I had to guess, I would say a distribution that is not for the person with a disability. So, for example, if they live with other people, that person can't pay the entire cable bill. Okay, they can pay their share of the cable bill. They can't pay for the vehicle that transports the entire family. That kind of stuff.
I see. So it's only for their basic living expenses. Okay.
Or a qualified expense. But like if you buy a computer, someone else might use it, but if it's primarily, you know, for the beneficiary and it's got applications and assistive technology on it for that person, that's going to be really clear. But if there's 3 kids in the house and everybody's using that same computer, that's not going to fly. Now, do you really think the IRS is going to figure that out? Probably not, but that's the answer. It can't be used for other people. It has to be used for the person with a disability.
Okay.
Now, let me give you an example. We have problems with SSI in a lot of special needs trusts, first-party special needs trusts, because we will put a provision in there that if the person with a disability is sick and they can't travel or is dying, that the trust could pay for family members to come and visit them and say their goodbyes, okay? The SSI, POMS, and SSA got real persnickety about that and said that we could not pay for other people because it was not solely for the benefit of the person with a disability, okay? That I think is questionable, but I see their point. So, but if the person's significantly disabled or is dying, they can't be the one to travel, you know. So I think you're going to have those kinds of tensions that we're not real sure how those play out. But again, if it's the IRS looking at this and not a Social Security Administration, I don't think they're going to have time to spend all this time on this like some of the workers at the Social Security Administration do.
Gotcha. Okay, so deposits can be made regularly into ABLE to cover housing expenses rather than giving in-kind support for housing expenses? Is that
correct?
Okay, and then is it possible that SSI will not be reduced because it's in-kind?
That's what the law says right now. Yep, it will not be reduced. Isn't that a wonderful thing? It is. That's the law. So if the person has a shortfall of $300 a month on their rent, their parent will put $300 a month in that ABLE account each month for that person to use that $300 to pay the rent, and there will not be an SSI reduction.
Okay. Okay, someone, just to verify, and I agree with this, so money that's in special needs trusts must pay back Medicaid upon the death of the special needs individual?
Only if it's a first-party trust. So if it's a trust funded with the individual's own money, that is the correct answer, or it's retained by the trust to help other people with disabilities in a pooled trust. If it's a third-party special needs trust, so a trust created with mom and dad's money or grandma and grandpa's or a sibling, there is no payback.
Wow, okay. So that's for special needs trust, if it's third-party money. Okay.
Right. So I like that idea of the parents only putting in a minimum amount into that account of their money because you don't want to subject third-party money to the payback.
Right. Okay, let's see. We're at the top of the hour. Looks like I have a couple more questions. Is the individual allowed to withdraw money from an ABLE account regardless of who opens it? So even if mom and dad opens one to be able to pay for housing, can the individual withdraw and spend on whatever he or she wants to buy?
Yeah,
or does the person?
Yes, they can. And if they don't have capacity because of the type of disability they have, that can be limited to their guardian, conservator, or their agent under a power of attorney.
Okay. Let's see. So someone is asking about the payable upon death statements. Not really clear on that point. Do you want to find out more about how what happens when, let's say, a person dies, and the different options, I guess, for?
I'll find out about the sibling provision for sure. But if you're talking about getting the statement from the state, you just tell the person died, and they're going to send you a bill. And it's going to have itemized things, like, did you have an individual plan of service every year? Did you have a monthly meeting with your sports coordinator? You know, all that stuff. And there is going to be a big assessment. Some people ask for it every year because they want to see. Some people don't. They figure they'll wait until if and when it happens because they're planning on spending it, so there's nothing there, you know. Everybody's going to be different.
Does earned income deposited into the ABLE account need to be reported for SSI purposes?
Yes. For purposes of determining SGA and their income disregards, yes. So the wages have to be reported, but once you get it, so the month you get it, it's income, but once you get it the next month, it's a resource, and you can put it anywhere you want, including the ABLE Act.
Say that again, please.
Including the ABLE Act account. So let's say you made $200 in that month, okay? That $200 has to be reported to SSI for them to do the SSI income determinations, okay?
Okay. For that
month. Then the following month, that $200 can go in the ABLE Act account if they haven't spent it.
Oh, I got you. Okay. Okay, I'm not sure I follow this question. If it can't be the individual's money that goes into the account, does that mean an individual can't deposit his or her salary into ABLE?
It can be the person's money, and that's the point of it. It can be either third-party money or the individual with a disability's own money. So they can put their wages in.
Okay. So there's another death payable upon death statements. What's the beneficiary responsible for paying back upon death? And so that would be
Medicaid expenditures from the date the account was open going forward, not all the way back. So let's say they've been on Medicaid for a while. Because this law just got passed, they're just doing an ABLE Act now. They only have to pay back. So if they opened one in 2007 and they die a month later, they're only paying for that month of Medicaid.
Okay. Well, so this is kind of similar. My child doesn't use his Medicaid benefits because he's covered under his father's health insurance policy. Would he then have to pay back Medicaid?
Not if he's not using it. If he's got it and he doesn't use it, there may be things you don't know about, like the school might be billing Medicaid. So, you know, it could be used for long-term care stuff or respite before that. But if he's not getting Medicaid because you don't qualify because his dad's working, and when he gets SSI at 18, he'll get it. And so you just got to watch, yeah.
Okay. Now here's a question that's, again, does Medicaid have to be paid back first before transferring the monies to a sibling?
No. And the other thing is Medicaid does not have to get paid for before you pay any outstanding qualified disability expenses, which is important because that prepaid burial and funeral thing might not have been done, okay? And so the person may die and you have 10 grand in there, they can pay for the funeral out of there before anything goes to the state.
Well, yeah, but I mean, again, that goes back to the, it just, yeah, I mean, if you'll do some checking on that, I mean, because I would think,
I'm not worried about it. But I can guarantee you, I've checked this 3 times because it sounds too good to be true.
It does. Okay, and that's a lot of the yeah, that's where a lot of the questions now are like, how can how can that be with uh, because then people would they would do everything they
Yeah,
could
but
to
not
avoid
everybody's
paying.
got siblings. There's not everybody has siblings, and it's got to be used for an educational expense. Because remember, this is modeled after the 529 rules.
Okay, okay, so I could transfer that money or transfer the money from my son's what was left over to my daughter, but she would have to use it for educational purposes.
Correct.
Even if she at the time, even if she's 65 years old at the time.
I don't know. This has been this law's not been around enough for me to know. I mean, I guess even at 65, you could take a music therapy or an art class. Yeah.
I guess you could do that. You could go.
Yeah.
Okay. There's a big difference.
I don't know the answer to all these yet. This is great. I love thinking about this.
So it says there's a big difference between SNT and ABLE. I don't know what SNT is.
Special Needs Trust.
Okay.
I apologize. Yeah.
So that's the difference. So in a special needs trust, you if it's first party money, you have to pay back.
There is a payback, or it's retained by the trust. And if it's a third party trust, mom and dad use it for their money, then there is no payback. That goes to the siblings or anywhere else mom and dad want that money to go to. And the state can't touch it, which is why I didn't like ABLE, because a lot of my clients wanted to use it for mom and dad to sock away money to save for their kid. And if it's mom and dad's money, I don't want to subject it to my state getting that money. And not all my clients have other kids.
Got it. Where do you set up an ABLE account? Can you set up at the bank?
No, each state has their own financial institutions they're working at. If you go to that national website, each state will tell you what financial people they're using. Some use Fidelity. I can't even keep track of them all. But that's why you want to shop it around. And I'll tell you what, my financial advisor was able to answer questions on this better than most lawyers I know, because they're informing themselves, because when they're meeting with their clients, just as they would normally suggest a 529 plan or a prepaid college tuition plan for their client, they're going to suggest ABLE Act accounts for their clients who have kids with disabilities. So they want to know what plan does what, where, kind of thing too.
Okay. So someone just asked, that sibling transfer is only for educational purposes. Yes, that's what we just, but
yeah,
we'll figure out what gets more information on that. Is a third-party non-family member, does an uncle qualify, or a parent, grandparent, to not allow a payback to Medicaid from a special needs trust?
That's right.
Okay.
So it's not have to be a parent or a grandparent. It could be their boyfriend, it could be their girlfriend, it could be Great Aunt Susie, it could be their in-laws, it could be a perfect stranger. Some people would rather the money go to a perfect stranger who's got a disability than the state,
Okay. My son does not receive SSI anymore, but he gets SSA. Can we, as conservators, open an ABLE account for him?
Yes. Your judge may want you to get court approval before you do it, and they may want it accounted for in your annual accounting. You will have to check with your judge what they want you to do. But it is clear by law you can do it, and I encourage you to do it.
Okay. So again, and we're starting to get some repeats, but so special needs trust money can be changed over to a sibling upon death of the special needs individual, but let me make sure, but if only third party money, not first party money.
Correct. Although if it's in a pooled trust, some pooled trusts will let that happen. If they are a trust that has 100% retention, some of the ones I work with do. So when the person with a disability dies, if there's still money there, they could name their significant other. So for example, I have clients who are both HIV positive and would qualify as a person with a disability, the one dies, they can say anything left in my sub-account goes to help my, my friend who also is a person with a disability, and there's no payback till the second one dies. But not all pooled trusts will do that.
Okay. So this is another question. It says, when we check with the banks, they did not know about the ABLE accounts, and so they need to go to the website and find out.
Yep.
How do you?
Because if you go to a bank and ask for a 529 plan, they're only going to tell you about theirs. So you want to go and get impartial information, and that website is the best place to go, or your financial planner.
Okay. How do you, like, if your state doesn't have an ABLE account or a stable account, how would you go about researching which state would be good for you? Because you said that every state varies. Yeah.
I would suggest you talk with your financial advisor. Like I said, when I started, my kids are in college and one's a college graduate. I went to my financial advisor and said, what 529 plan do I want? And she goes, I like this one. They're getting better return. They have less cost. That's what I used.
Okay.
So I think there are going to be some financial folks who will know. I would say Michigan's is still pretty new. I probably, if it were my clients or kids in Michigan, I'd probably go to Ohio's, because it's been around longer. I like their investment mix, and Michigan's hasn't been tested enough yet for me to feel comfortable.
So really,
it might be different in a couple months.
So you either need to find somebody who knows about all the different state accounts, or someone who does a lot of research to figure out what's going to be the best one for them.
Right, or just use that chart. I mean, there's not going to be a whole lot of deviation from it. You know what I mean?
Okay.
You're going to want to look at the fees. You're going to want to look at the investment advisory mixes. Most of them, if I understand correctly, are offering one or two options, sometimes more, so that you could say, okay, I like this investment mix. I like who they're using. They've got Fidelity. I'm going to use these people. You know what I mean?
Oh, I got you. Yes. Okay.
And I think that it might be a good idea to have one of these programs maybe next year, and then we could have more than one person on here. We could talk about the pros and cons and how some of this is fleshed out after another year or so.
That's a great idea. We'll do that because I'll take a couple more questions and then we'll let you go. And then it says the maximum amount mentioned, it can be up to $100,000. That's what it was? Isn't that what you said?
That's the total amount in the account before SSI gets suspended, but you can put $14,000 a year in total. Not each person can put $14,000 in.
Okay, but that's going to change. That amount's going to change every year, isn't it?
Yeah, but it sometimes it only goes up a teeny little bit.
Okay.
I mean, it was $10,000 when I started practicing 20 years ago, so it hasn't gone up a lot.
Okay. So someone's asking about a third party, so that would be, and part of it is I want to make sure that I've got this too. So if my son puts in money, he's considered first party. That's his money.
Correct.
But a third party would be parents, grandparents, aunts, uncles, other. So, okay.
But both are subject to the payback and enable, where if those parents and grandparents already had a third-party trust, and you had a 529 plan held in that trust, they could just put it in there. You know what I'm saying?
Yes.
You don't have to do a special needs trust. The whole joy of these ABLE Act accounts is you don't have to see a lawyer. And I don't blame you. You got enough lawyers you got to deal with. But if you have, don't subject third-party money to that payback. Don't give it to the evil empire. Give it to people with disabilities if you can, or other family members.
Well, how about if we take one more question, and then what I'll do is I'll forward additional questions to you, and are we going to try to?
Then I'll follow up on the question about the remainder for sure, and then when we link these, we can put some of the frequently asked questions up too.
Perfect. So, so this is a good one, and so my child and his uncle both have Fragile X. Could the uncle's ABLE account go to his nephew's ABLE account upon the uncle's death?
Absolutely.
Okay. So it's not a sibling, though. It is a family member, but it's not a sibling. Is that okay?
But if you remember, it can go to another person with a disability. I'm pretty sure it said, let me triple check that one too, but I'm pretty sure it can.
Okay. And then we'll end with this one. It says, when you go to the national site, what is the national site? What's the best website to go to for more information?
It is the ABLE National Resource Center. And if you look on slide 29, it is the second website listed.
Right. It's right on the screen right now.
Okay. So everybody look at that. I don't know, David, can we pull the rest of the questions off this webinar, or should I have people email them to me?
Have them email it to you.
Okay. Did you guys hear that, everyone? If you have additional questions, send them to Jayne@fragilexf.org. That's Jayne. And then I will pass them on to Patty, and we're going to have a Q&A section that goes along with the webinar once we get that online. All right.
And you can tell I clearly don't have all the answers, but I'll find them.
Patty, this has just been just wonderful. It's
Well,
been
good.
so.
If people have other topics they would like to have one on, let me know. I'm happy to help.
Well, that's great. I think we'll probably take you up on that too. So email me that too. Anybody who would like to have any additional information. I know that every now and then we have a lot of discussion on Facebook about guardianship, conservatorship, and other protective arrangements, and so
yeah, we might want to do one on that. I have a commonly held myths or old urban legends about guardianships and conservatorships that I like to do, because there's a lot of misinformation out there on that.
Right, and I know it's tricky too because it varies so much state to state.
Right.
I've seen that. So anyway, thank you, Patty, for sharing your expertise with us. It was just outstanding. So thank you.
Well, thank you so much. Everybody have a great day.
Well, I wanted to let everyone know we have one more webinar in this calendar year, and it's our annual one with Dr. Craig Erickson on medications, and it will be on November 2nd. So watch your emails. Again, these webinars are made possible by your donations. Please consider making a donation to the National Fragile X Foundation at fragilex.org. Patty, do you have any final words?
No, thank you. I hope this was helpful.
Thank you so much. Thank you, everyone, and have a great day.
Bye-bye.